Welcome back. We are shifting our focus back again to the Supreme Court, which did something rather unprecedented today. The top court has sent a Lucknow judge back to law school. His crime, not complying with the Supreme Court's specific order and refusing to grant bail to an accused in the case. The Supreme Court made it very clear. Not granting bail in a case where custody is not needed amounts to intellectual dishonesty on the part of the judicial officer. Let's take a quick step back and revisit the Supreme Court's order on March 22nd, which, according to the Supreme Court, needs to be the Bible for bail cases. The Supreme Court had gotten very upset with the lower and trial courts and said that bail is the norm, jail is the exception. Let me repeat that for you. Any law student will tell you that this is the first thing they are taught in law school, that bail is the norm and jail is the exception. It was observed that some judges were passing custody orders in a routine manner, denying liberty to the accused. So the Supreme Court said to ensure that the order is complied with, the Supreme Court will send non-compliant judges back to academies for upgrading their knowledge about basic law. Now, in this case, the Lucknow judicial officer, well, he had already served 30 years in the judicial system. He says, look, I have just 1 month to retire, so don't send me back to a law academy. It is humiliating. But the Supreme Court said no. The very fact that you have been a law officer for such a long time and yet you have not upheld the basics of the law means that you need to get your knowledge upgraded. The Supreme Court also made it very clear that this particular judge will not get a promotion to the High Court. Now, what does this mean? The Supreme Court's March order actually was an extension of its verdict in July 2022. Nearly a year ago, India's apex court had issued very clear instructions to lower courts. The court was referring to instances where either the accused is awaiting trial or has been accused of petty crimes that require a sentence of less than 7 years. And today, the court observed that the lower court judges are defying the Supreme Court order over and over again. The Supreme Court is making its stance very clear. Those accused of non-heinous crimes must be given bail on personal bond of good behavior. So why is it that lower court judges are repeatedly defying the Supreme Court order? If what the Supreme Court has said is the law of the land, why are trial court judges not complying? Look at some of these cases. A cancer patient is accused in a corruption case. He's pleading not to be sent behind bars. Or a marital dispute where a husband is simply seeking anticipatory bail. And in cases where the accused is cooperating with the agencies, is there really any need for a lower court to put them behind bars? You know what this is doing? What this is doing is overcrowding our prisons as well. You are denying people their basic rights. If the Supreme Court of India is saying that bail is the right of every citizen who has committed a non-heinous crime, then you are denying the citizens of this country their basic human rights, right? You're also, by the way, overburdening our judicial system and our prisons. Take a look at the number. These are some prison numbers I want to put out for you. Of all prisoners, 77% are under trial, meaning the court has not found them guilty so far. Why are they in jail? Especially those who are, who are accused of non-serious crimes. Now, these 4.3 lakh inmates are simply waiting trial. And what has this resulted in? A severe prison overcrowding problem. Just hear me out. India's jails are occupied beyond capacity. To be precise, our jails have an occupancy rate of over 130%. 130%. What is more shocking is how staffing in prisons has gone down by 30%. So essentially, the number of prisoners is going up, but the jail staff is down. It's down by 30%. So from doctors to prison guards, we have a shortage of those who manage these prisons while the number of inmates continue to swell. This not only deprives the inmates of basic human rights, but also overburdens the judicial system that is already choked with 5 crore pending cases. Varun Thakur is an advocate of the Supreme Court, joining us on the broadcast. Namit continues to be with us. He's an advocate of the Supreme Court. Varun Thakur, what exactly seems to be the problem? This is not like, we've just listed out maybe 3 instances where the Supreme Court has said that bail, not jail, is the law of the land. The Supreme Court, I think, must have said this 1,000 times over the last 10 years. Why is it that the lower judiciary simply refuses to listen? What's the problem? If there's a cancer patient who is accused of a fraud of 50,000 rupees, why is he being sent to prison? Why is he being denied bail? In the case of this particular Lucknow judge, he denied bail to a man accused in a matrimonial case, for heaven's sake.
Shreya, in this situation, parliamentary law is not clear. Supreme Court repeatedly says, because our constitution framework is this, Article 21 is a very precious right, and no one can snatch this right without due process of law. And suddenly, who sent the behind the bar and snatching the liberty of the people, this is a very precious right. So regarding this aspect, Supreme Court repeatedly says, requested the Parliament regarding the frame the comprehensive, regarding the bring the law. But in vacuum of the law, Supreme Court framed some guideline. So they repeatedly says, follow the CRPC provisions. First, you give a 41 notice, CRPC. Thereafter, they are not cooperating, then you maybe send it. And certain special act is also involved. So lower judiciary also in dilemma sometime. And in the ground reality is completely different. Regarding these aspects, sometimes because they are in the ground level, so they understand the consequence of they are giving the bail. Sometimes people are protested. But section is not like this. The maximum punishment is more than 7 years. So if person arrest and they giving immediate, they are not put behind the bar.
Fair point. Fair point. Fair point.
Yes, Shreya.
Let me get in Namit Saxena here. You make a very fair. Give me a moment here. Let me get in Namit Saxena as well. Namit Saxena, Varun is telling me, as far as the lower court is concerned, there is a dilemma that the Supreme Court can say that bail is the norm, jail is the exception. But there is a certain dilemma and apprehension as far as the lower courts are concerned. What is this apprehension? If the Supreme Court has even told you under what circumstances you don't need to give bail. If it's a heinous crime, if you have someone who's a repeat offender, if you have if you have someone who's a serial killer, don't give that person bail. You understand that if that person walks out, he'll probably murder 5 other people. Don't give a serial rapist bail because you know that if he walks free, he may rape 3 other women. But apart from that, if there are people accused in matrimonial cases or fraud cases, why keep them behind bars?
See, I don't think there is any dilemma at all. The law is very clear. The law is, after Satyendra Kumar, until if you're not arrested during investigation and charge sheet is filed, you're duty bound to be released on bail once you, appear and say that, your presence is secured for the purposes of conduction of trial. I don't think there is any dilemma. So there is a list of 8 factors which are to be considered by the court while deciding bail. These include gravity of offense, severity of punishment, flight risk, previous antecedents, the scope of tampering of witnesses, etc. There's a list of 8 factors which the court has to consider. And the Supreme Court has said this in umpteen number of judgments. Perhaps legally there is no dilemma. There may be a dilemma in the back, in the mind of low court judges where they think that in case we grant bail, and somebody challenges and it goes, to appellate courts or to high courts, they may think that, we may have granted bail because of some ulterior motives, or there can be something behind the back, something behind the curtains. So they are slightly apprehensive in, granting bails in early stages of investigation or early stages of trial. That is why, the Supreme Court and umpteen number of judgments has also said, and right now, the Supreme Court judges have been very vocal in public speeches also. They're observing in, during court proceedings also, that please don't hesitate, follow the law, whatever is there. See, granting bail is a discretion. Discretion is to be exercised on judicial principles. The judicial principles the Supreme Court has given in multi number of judgments. So if you follow those principles, you won't be, bracketed out. What has happened in this case where Justice Sanjay Kishan Kaul has made these observations today is that in the matrimonial matters, that the Sessions Court refused to grant bail. That is where they said that this is basics, of criminal law. And umpteen number of judgments in which we have held so. So in case you are not following those judgments, in case you are not following what is, held in section 439 CRPC also, then you are duty bound, then we are duty bound rather to send you to, a judicial academy, you please learn the law and then come back. What has happened today is Mr. Patwalia mentioned this matter saying that this particular judge is in the zone of consideration to become a high court judge. So the Justice Sanjay Kishan Kaul said there's nothing doing. We can't, all the more reason that we can't, lift him upwards to become a high court judge, because he'll do the same thing in the high court also. Then we'll be burdened again. Then you'll see High Court is also not granting bail. Now we'll come in SLP before the Supreme Court and please grant us bail. It is as simple as this. So I think the Supreme Court is absolutely right in observing this, that that you have to please understand basics of criminal law before before deciding bails. Right. So in my opinion, there is no dilemma at all.
All right. This is an interesting case. This is a very interesting case. The fact that I'm completely out of time, I'm afraid, Varun, but this is an interesting case because the Supreme Court essentially has sent a judge with 30 years of experience back to law school simply because he is not following that basic principle of law, that it is bail, not jail. That is the norm in this country. It's an interesting case. Will it set a precedent? Will lower court judges, trial court judges be a little more careful once they are denying bail? We don't know. We'll have to just wait and see. We'll leave it there for the moment. Thank you very much for joining us, gentlemen.